Good morning. All right. Morning, everyone. Looks
Morning.
like the first person we have this morning is Ivanson, Alouidor.
Hello,
We have the interpreter.
Both interpreters are on Zoom.
Okay.
This is the Haitian Creole case.
Is he acknowledged?
They do know that.
Can we proceed?
Yeah.
All right, Mr. Interpreter, can you hear us?
Monsieur, vous m'entendez?
Oui.
Yes.
All right, before we begin, I've already read all of the court services notes. Please interpret.
I'm sorry, could you please repeat that?
All right. Before we begin, I want to inform everyone, please interpret.
Avant de commencer, moi ap informer tout le monde.
I've read the entire file for each one of the individuals today. Please interpret.
Moi li tout de dossier et de individus ça aujourd'hui.
So I'm familiar with the probable cause sheet and the other information in the file.
Moi familier ensemble avec cause probable, ensemble avec l'autre information qui gagne dans dossier.
All right, Mr. Hydrant, is the state ready to proceed? Please interpret.
OK, monsieur, est-ce que l'État prêt pour que vous continuez?
Yes, Your Honor. Prior to beginning, however, I would inquire of the jail as to whether or not there is an ICE hold in this case.
Oui, juge, nous prêt pour nous continuer, mais moi gagne pour demander dans prison, est-ce que gagne ICE qui gagne intention que be moun nan?
Yes.
Oui.
Thank you, Your Honor. In that case, the state is seeking bail in the amount of $50,000 bondable.
Dans cas ça, l'État m'a dit que li ka paye yon bon $50,000
Pretrial supervision.
pour gagner pré-jugement, supervision.
If Mr. Ailador does post that amount.
Si monsieur Alidor ka paye caution ça.
No firearms or weapons.
Puis gali en possession de aucun arme, aucun type de arme.
No contact with the named victim.
Aucun contact ensemble avec victime dans le dossier ça.
And house arrest with GPS monitoring.
Et puis pour que li sous arrestation et dans résidence ensemble avec un moniteur qui gagne un GPS sur lui.
While Mr. Ailador does score a 3 on the risk assessment.
Pendant que M. Alidor il fait jusqu'à 3 points le que yo fait en évaluation pour lui.
It does appear that he has only been in our community for a short time.
Il paraît que li dans communauté nous seulement pendant un petit classe.
His only criminal history noted is a 2024 alien inadmissibility arrest out of Texas.
Et seulement ça li gagne comme dossier c'est yon arrestation parce que li pat admis et normalement dans pays.
I would also ask that given the facts of this case, he be given no 10% cash option.
Et puis, par rapport ensemble avec ça, tout, moi, t'as demandé que yo pas bali aucun 10% et cash option.
We did contact the victim in this case.
Nous t'ai contacté victime dans le dossier ça.
However, given the language barrier We were unable to have sufficient contact with him.
Malheureusement, par rapport ensemble avec communication qui est difficile par rapport ensemble avec langue et que nous parlons, nous pas arrivé à entrer en contact avec elle.
But given the facts, we do believe that the no contact order to be appropriate.
Mais malgré ça, basé sur fait, nous pensons que l'ordre pour que pas gagner contact là, nous pensons que est approprié.
And on that, I'll submit.
Et après ça, je finis.
All right, do we have a response?
Est-ce que nous avons une réponse?
Yes, at this time, we're seeking a lesser amount in bail to the effect of $5,000 bondable.
Après ça, qui se dit, nous avons demandé et nous avons mis en requête pour que gagne une caution pour la guerre qui moins que comme que on demandé à qui t'a $5,000.
I believe the charge itself is severe enough to warrant monetary bail.
Moi pense que charge non pour compte qu'on parle sévère assez pour que yo la guerre ensemble avec un moniteur sous lui.
But his absence of any prior criminal activity reflects that this conduct is an outlier, not his regular course of conduct.
Et absence que de aucune arrestation ou bien et crime que les commettent déjà montrer que ça qui arrive c'est pas un bagage que il fait régulièrement mais c'était un bagage qui sorti de l'ordinaire.
His MPRA reflects that he is not a regular risk to the community nor a flight risk.
Historiquement montré que li pas et un risque pour communauté ni li pas gain aucun risque pour que l'État voyager.
He has verified employment and a verified phone, so he has worthwhile contacts in our community to make it believable that he would be successful on supervision.
Li gen un numéro de téléphone qui vérifié, li gen un emploi qui vérifié. Donc tout ça c'est des éléments qui solides qui montrent que ça c'est un monde qui ancré dans la communauté qui pas gen aucune intention courir.
I'm asking this court to give weight to the MPRA in its bail determination, and that is why I believe $5,000 bondable is an appropriate outcome.
Donc, moi, demandé que le tribunal t'a considéré tout élément ça yo, et c'est ça que fait moi penser que yon et caution $5,000, c'est ça qui est approprié.
All right, so the facts of this case are very concerning.
Donc, élément qui dans dossier ça est vraiment inquiétant.
His bail is going to be set at $40,000, no 10% cash option.
Et caution, moi, ap mette li à $40,000 et yo pa bay et 10% cash option sous li.
No contact with Huguener Velsma
Puis ga ou entre en contact ensemble avec Huguener Velsma.
and Stephen, same last name as the defendant.
Ni Steven tout et li gen Steven nan gen même signature ensemble avant.
Residential confinement,
Yo ap kenbo la kayou.
shall not possess firearms or weapons, and pretrial
Piga-
services vision.
Puis ga ou gen aucun zam à feu ni aucun zam blanc sou et puis pour gagner et service pré et jugement tout.
All right. Thank you, Ms. Interpreter.
Thank you, Your Honor. Have a great day.
And you.
Thank you.
All right, the next individual is Eduardo Enrique. And then I have that JLL. First one.
Okay.
Zach will work on that.
Okay.
All right, Miss Interpreter, are you available to interpret in Spanish?
Hello, Your Honor. This is the Spanish interpreter, Manuel, ready for your instructions.
All right, is the state ready to proceed with Mr. Enrique?
¿El Estado está listo para proceder con el señor Enrique?
Yes, Your Honor, I am.
Sí, su señoría, lo estoy.
Your Honor, in this case, the state is not going to object to Mr. Enriquez's release.
Su señoría, en este caso, el Estado no objetará a la liberación del señor Enrique.
We are going to ask that he be supervised by pretrial supervision or pretrial services and be tested for alcohol.
Vamos a solicitar que sea supervisado por los servicios previos al juicio y que se realice pruebas de alcohol.
We would also ask that he complete the DUI rant.
También estaremos solicitando que complete el curso de conducir en estado de ebriedad
And have a condition that he not drive without proper documentation.
y también que se dictamine la condición de que no tenga permitido conducir si no cuenta con la documentación apropiada.
He does score that 8 on the criminal history, and he does have some minor misdemeanor history.
Al revisar sus antecedentes criminales tiene un puntaje de 8 y tiene algunos antecedentes de delitos menores,
Including a misdemeanor battery conviction from this year out of the Sparks Justice Court,
incluyendo una condena de un delito menor de agresión física del Tribunal de Sparks este mismo año.
the underlying driving under the influence first offense from 2025 out of the Sparks Municipal Court,
Con el delito subyacente de conducir en estado de ebriedad, primer delito del año 2025 del Tribunal Municipal de Sparks,
and a misdemeanor assault conviction from 2024 out of this court.
y una condena de un delito menor por agresión del 2024 de este mismo tribunal.
And all that I'll submit.
Con eso lo dejo a consideración.
All right, do we have a response?
¿Tenemos respuesta?
We're seeking an OR at this point in time. Again, I believe Mr. Enriquez can be successfully supervised on pretrial release.
Nosotros solicitamos libertad bajo palabra. Yo creo que el señor Enríquez puede tener la supervisión previa al juicio con éxito.
All right, so Mr. Enrique will be released, but he's going to be subject to residential confinement. Please interpret.
Muy bien, el señor Enrique será puesto en libertad, pero tendrá que estar en confinamiento domiciliario.
Tested for alcohol and obtain a DUI
Good.
rant.
Tendrá que hacerse pruebas de alcohol y un curso de conducir en estado de ebriedad.
No driving without a license and insurance.
No tendrá permitido conducir si no cuenta con licencia y con seguro para el vehículo.
And pretrial supervision.
Y tendrá supervisión previa al juicio.
Is there anything further?
¿Algo más que agregar?
Not from the state. Thank you, Your Honor.
No por parte del Estado. Gracias, señoría.
I'm just asking about the arraignment date.
Solamente quiero pedir la fecha de la lectura formal, por favor.
March 26th at 9 a.m.
Not gonna be the same.
26 de marzo, 9 de la mañana.
All right, thank you, Mr. Interpreter.
Thank you for using our services, Your Honor. I hope you have a great rest of your day.
Same to you. Next is Mr. Katz.
Your Honor, my apologies. I would just note for the court that we do have one victim present for the case involving Mr. Jose Solorzano. So I would ask that that be called at or near the top of the calendar for her convenience.
All right. Which individual was this? Ms. Katz.
Thank you.
You'll notice some of these are still file stamped from yesterday, so I'm gonna have to redo those. Okay, you saw Mr. Saldana.
Solorzano. Number 13.
All right, so let me get Mr. Lorenzo. Okay. Is the state ready to proceed with Jose Solorzano?
The state is prepared, Your Honor. I'll just wait for him to reach the counter.
Good morning, Your Honor.
Morning.
Your Honor, in this case, the state is seeking bail in the amount of $40,000 bondable, pretrial supervision with testing for drugs and alcohol. We are asking that a no contact order be issued at this point, pursuant to court order only. It is my understanding in reviewing the notes from my investigator and who spoke with Ms. March this morning that she does not believe a no contact order is necessary at this point, but is not supportive of Mr. Solorzano coming back to the home at this point. So at this time, the state does believe that it is, given the facts of this case, appropriate to have the no contact order issued. We would also ask for a no firearms or weapons clause. Mr. Solorzano scores a 12 on the risk assessment, noting 2 points for prior failure to appears and 2 points for prior violent crime convictions. Also noting that he was released from custody on February 18th of this year. Between this year and last year, Mr. Solorzano had 3 failure to appear arrests, a failure to appear arrest in 2024, a 2019 felony conviction for felon in possession of a firearm, a 2018 misdemeanor conviction for domestic battery first, a second misdemeanor domestic battery first conviction, and a felony conviction for attempted robbery. He then had a misdemeanor DUI conviction in 2017 out of the Sparks Justice Court and a 2013 misdemeanor conviction for reckless driving. Given that, Your Honor, and that recent domestic battery history, we do believe that Mr. Solorzano presents an ongoing risk of further criminal activity, risk to this victim. He does have a significant amount of violence in his past. So that is the basis for the higher level bail, as well as the no contact order at this point. And on that, I'll submit. And it is my understanding, unless Ms. March has changed her mind, that she did not wish to address the court this morning.
All right. Is that accurate, Ms. March? She on mute?
Yeah.
She is muted, Your Honor, but
Okay, understood. I'm gonna accept your representation. Do we have a response?
Yes, so at this time, we're seeking a lesser amount in bail to the effect of $3,000 bondable with a 10% cash option. While Mr. Solorzano scored a 12 on the MPRA, what needs to be factored in for his bail amount is that there's no points for prior multiple substance use arrests, which should mitigate some level of a flight risk or a failure to comply. In addition to that, we were able to reach a reference for Mr. Solorzano. That reference was able to verify that he is currently employed, so he would have work to return to. In addition to that, Mr. Solorzano has represented to us that he would be able to stay with his father if need be, so he could maintain the integrity of having no contact with the alleged victim during pretrial release. He is also amenable to any other pretrial release conditions that the court believes is appropriate. I think a no contact order pursuant to court order is permissible. Along with that, he is amenable to random drug and alcohol testing and a no weapons clause.
And does this father reside at 1405 South Rock Boulevard, Unit 118?
Yes, Your Honor.
All right. All right, I am gonna set his bail at 30,000, however. No contact with 980 Curdy Drive, no contact with Jennifer March, and no contact with Rosali Rosalie, Rosally, same last name as the defendant in this case, subject to testing, shall not possess firearms or weapons, must reside at 1405 South Rock Boulevard, Unit 118. He'll be subject to pretrial supervision. All right, given the facts of this case, I believe bail is appropriate.
Sure.
All right. So now we can go back to Mr. Katz.
Oh, shit. Right.
Mr. Katz, can you hear me?
Yes, sir.
You indicated that you're going to retain private counsel. Is that accurate?
Yes. Yes.
I'm sorry, did you say yes?
What does that mean? Private counsel.
That means you did not want a public defender, which I find that unusual.
No,
So
I
I would
didn't.
like to appoint a public defender for you.
Yeah, I did
All
want to.
right?
Yeah.
Okay. All right, is the state ready to proceed?
And then Judge, he does have a no jail complaint as well.
Okay,
That is,
is that next?
yeah, they're both on. Both cases are on.
Right,
Judge,
okay,
I spoke with Mr. Katz earlier today. He intends to enter a plea pursuant to that no jail status if the court is willing to entertain it.
yes, I am. Let's start with the first appearance, though. State ready to proceed?
Yes, Your Honor. In this case, the state is going to seek bail in the amount of $40,000 bondable, pretrial supervision, testing for drugs and alcohol, and no weapons. Mr. Katz scores a 7 on the risk assessment, noting the active pretrial case for the one that is going to be addressed next. He was released on that case with monitoring and then immediately picked up this case. Also this year, he was arrested on a disorderly conduct or peek in inhabited building or loitering in Fairfield, California. Outside of that, Mr. Katz appears to have no other criminal history. However, it does appear, given the conduct, that he is either suffering from mental health or drug and alcohol abuse issues. So we do believe he presents an ongoing risk to the community and further criminal activity, especially given the nature of his repeated arrests within the short time frame.
All right, do we have a response?
Judge, to clarify, is the public defender appointed?
Yes,
All right. Regarding bail, his bail should be no greater than $3,000 bondable with a 10% cash option. The filing of the criminal complaint is one charge of pedestrian walking on highway. The state has not carried its burden of proof, showing by clear and convincing evidence that there's no other means to ensure safety of the community and assurance that Mr. Katz will maintain court appearances going forward. Certainly not to the effect of $40,000 bondable. Given the score on the MPRA, no prior misdemeanors, no prior felonies, no violence, no failures to appear, no multiple substance use arrests. This is clearly an outlier for Mr. Katz's conduct. I think an OR release is appropriate with check-ins with pretrial services. Anything more than that is probably too oppressive for what the circumstances actually warrant.
I would agree with that to a certain extent. His bail is going to be set at $10,000 with a 10% cash option. Although it wasn't very clear, looks like he stole the hammer from a job site 4th and Ralston, so that will be part of my no contact order. Shall not possess firearms or weapons, subject to pretrial services supervision. He was on Reno Justice Court monitoring at the time of his arrest, which is another reason why I think bail is appropriate. All right, the public defender will be appointed to represent you. And then you have the PDF, right, that I signed? Okay. All right. Next
You
individual,
want to do his no jail?
yeah, I'm sorry. I was gonna say next individual is Mr. Katz again.
Okay.
Sorry about that. All right, this is his arraignment. It's like it's a no jail complaint. Let me take a look at his complaint briefly here. All right, just to confirm for the record, Mr. Barnes, have you read the complaint to your client? Is his name correctly spelled on line 7 before he enters a plea?
Judge, it's Mr. Merritt, and I've reviewed the criminal
Barrett, I'm
complaint,
sorry.
Mr. Katz. His name is spelled correctly on line 7. He's familiar with the contents of the document and will waive a formal reading.
All right. Doesn't it say Mr. Barnes up there?
It's because that's the deputy that's logged in.
Okay, all right. Okay. All right, Mr. Katz, it's my understanding that you want to enter a plea to the misdemeanor charge of pedestrian walking on a highway. Is that your understanding?
Yes, please.
All right, do you understand by entering the plea today, you're waiving valuable constitutional rights, including your right to go to trial on this matter and contest that charge? Do you understand that, sir?
Yes.
You understand the consequences of your plea?
Yeah.
You understand that once you enter that plea, I'm not required to follow any recommendation that has been given to you by the public defender, and I can also impose my own sentence. Do you understand that, sir?
Understand.
What is your plea to the charge misdemeanor pedestrian walking in a highway?
Guilty?
All right, court finds you've entered your plea intelligently, voluntarily, with the knowing understanding each element of the charge and consequences of your plea. Court accepts your plea of guilty. All right, so with respect to that charge, I'm gonna give you 1 day credit for time served, all right? So that you don't have to worry about this case anymore.
Thank you.
Okay, next individual is Adam Brenner. All right, is the state ready to proceed with Mr. Brenner?
Yes, Your Honor. For the court's information, this was continued yesterday for victim contact. It does not look like she is going to be cooperative with our office. So at this point, we are prepared to move forward. The state is going to seek bail in the amount of $40,000 bondable, pretrial supervision, no contact with the named victim. Mr. Brenner scores a 10 on the risk assessment, noting 2 points for prior substance abuse related arrests. In 2025, he had a probation violation arrest with no disposition. In 2024, he had a DUI and drug paraphernalia arrest with no disposition. And then in 2017, he had a misdemeanor conviction for attempted engage in prostitution out of this court, a misdemeanor resisting out of this court, a failure to appear arrest, a drug paraphernalia conviction out of this court, and a misdemeanor coercion out of the Sparks Justice Court. So, Your Honor, we do believe that bail is appropriate in this case, given the facts and the likelihood of, well, I can't say likelihood of conviction given the victim stance. So that would be our request this morning.
All right, do we have a response?
Yes, at this time, we're seeking an OR release for Mr. Brenner with appropriate release conditions. I believe check-ins with pretrial services is a strong idea. I'm not seeing any additional requirements that would be appropriate under these circumstances, but I'm sure the court will fashion what they feel is correct. While Mr. Brenner scored a 10 on the MPRA, there were no points for prior felonies, prior violence, and prior failures to appear. So whatever risk to the community he does pose is a fairly mild one. Now turning to whether or not he's a flight risk, I do understand that it sounded like there may have been some issues in prior supervision. In speaking with Mr. Brenner, he reports to us that he does currently have employment. He has an address he could return to, and he does have a personal phone. If all of that were to be verified with his reference, that would have marked his score down from a 10 to likely a 6. That would make him a mid-moderate risk. Again, I think with appropriate pretrial release conditions, that I think Mr. Brenner could be successfully supervised in the community. And then given the status of the alleged victim, the provability of this case is kind of in the wind. That should be factored into whatever bail amount is set on this case.
Right, were you able to verify some of his information because court services did not?
I was not able to. We called the reference twice, but she was never able to reach back out to us. Not at this point.
Does he still reside at 1001 South Meadows Parkway, Unit 827?
Yes.
Okay. So in this case, I'm gonna set his bail at $25,000. No contact with Stephanie Steele. He'll be subject to testing, shall not possess firearms or weapons. He must reside at the address in the court services note, which is the 1001 South Meadows Parkway, Unit 827, will be subject to pretrial supervision. Facts of this case are concerning, as well as his criminal history. All right. Next is Emma Beal, followed by Alina Condrone.
Good morning, Your Honor.
Morning.
Your Honor, on this case, I am not prepared to move forward based on victim contact, and I will be requesting a one-day continuance.
All right. Bear with me here because I want to go through my notes on this case.
Yes, Your Honor.
Were you able to try to reach out to her this weekend at all?
Yes, Your Honor. We attempted to contact the victim initially last night and again this morning with still no contact.
All right. Okay. All right. So we'll have to bring back Ms. Beal tomorrow.
Judge,
Yes.
am I able to make a record on this?
Yeah, you may, absolutely, anytime.
In hearing the state's request, we oppose it. Given the stature of Ms. Beal's case, she was originally arrested on the 6th at 9:15 p.m. If we continue this again, that's going to put us outside the 48-hour window in which Ms. Beal is entitled to a bail hearing. With that in mind, she is also a stay-at-home parent, the only stay-at-home parent who has actually cared for her 2-year-old infant. That child is left in inept hands while Ms. Beal is left in custody without bail. So in the interim, we would ask that we move forward today with the bail hearing, especially given the fact that the state has already tried to reach the alleged victim and has been unable to do so.
Do you have a response, Mr. Heydrich?
Yes, Your Honor. I do note that we got this case yesterday. We attempted to contact the victim expeditiously. Have not received contact yet. This is a Saturday, Sunday. not a work weekend, so I understand that we will be pushed outside of the 48-hour window. However, Your Honor, to limit or reduce the prejudice against Ms. Beal, she does have a pending case against her in this court, and that is RCR 2025-132-606. That is set for status conference on March 16th. Given the new arrest, I believe that she is also able to be taken into custody and bail imposed on that case. So, Your Honor, I think that there is, while some prejudice to Ms. Beal, the facts of this case are very concerning. She is, what the provability of the case is high. She was caught on camera less than 100 yards from the residence, as is mandated by the extended protection order, while she did remain in her vehicle honking the horn. This was a conscious disregard for the terms of the protection order, which she did indicate she was aware of. She also scores a 6 on the risk assessment, and she does have other limited criminal history, and it is out of the state of California, but it did involve originally a crime of violence and a domestic battery that did resolve for an offensive words in public. So, Your Honor, we do believe that a continuance is appropriate in this case to attempt to contact the victims.
All right, and then in reviewing this file, let me make sure I got my notes correct. The active RJC is for battery, correct?
That's correct, Your Honor.
Did it involve the same victims?
It did, Your Honor.
And that's scheduled for March 6th,
Yeah, I think
16th, Your Honor, 8 days from today.
16,
Mhm.
and it's shown as a citation.
Yeah, it came in as a citation, so there really was no bail hearing or anything on that, so.
Right? So, Ms. Beal, you understand that if I move forward with this case, that you cannot contact either Todd or Manuela Pardula or 645 Oxbow Court. You understand that, Miss?
Yes, Your Honor.
All right, I'm gonna move forward with this case. I understand your concern, Mr. Hydrick, but I think given the circumstances of this case, I'm ready to proceed.
Thank you, Your Honor. Your Honor, so we are seeking bail in the amount of $10,000 bondable, pretrial supervision, house arrest with GPS monitoring, given the violation in this case, and absolutely no contact with the named victims. Further, we would also request that a no firearms or weapons clause be included, given Ms. Beal's conduct. As noted, she does have the pending battery before this court against the same victim, Ms. Manuela Pardula. Her only other criminal history, as noted, was a 2020 misdemeanor conviction for offensive words in public. That case originated as a domestic battery. However, the domestic battery charge was dismissed. So, Your Honor, given that, we do believe that some bail in this case is appropriate, as noted in my original argument, given the facts of this case.
Understood. All right, do we have a response, Mr. Merritt?
Yes, at this time, we're seeking to know our release for Ms. Beal with appropriate release conditions. I think a no contact order is the most essential release condition for sure. Now, in terms of other release conditions, I think check-ins with pretrial services would also be appropriate, and a no weapons clause as well. While Ms. Beal initially scored a 6 on the MPRA, in that 6, there's no felonies, no violence, no failures to appear. She had a verified residence, no multiple substance use arrests, and a verified phone. She's not a flight risk, and whatever threat to the community she does pose, it's fairly mild. The charge she is facing now doesn't involve physical violence to another person, nor does it involve theft. It is just inappropriate contact at one point in time. Not to get too murky in the facts of the case, but it was predicated on the need to commit a welfare check on her infant child that was at the residence, and local law enforcement was unwilling to do so. So Ms. Beal, the caring mother that she is, she felt like she had to go over and do something. Ultimately, it was the incorrect thing to do, but I think that needs to be factored in, right? Her disobedience or alleged disobedience of a court order was not on a whim. It's not her way or the highway type deal. It was predicated on real life circumstances that really any rational parent would have done something similar. I think with that in mind and her lack of serious criminal activity in her criminal history, I think this case is an appropriate own recognizance release type of case, again, with appropriate release conditions consistent with what the circumstances actually necessitate.
All right, were you able to verify her address?
I left a message with her reference. Her reference was unable to get back to me in time.
All right, does she still reside, or do you know, do you reside, Miss, at 2209 Kitski Lane, Unit C?
Yes, sir.
All right. You know, the officers, when they questioned you about this case, Miss, you told them that you were over 100 yards from the residence, and when they showed you the video, you were obviously on the curb, which is not 100 yards. Nevertheless, given the facts of this case, I'm going to set your bail at $2,000 or a 10% cash option. No contact with or Manuela Pardula, 645 Oxbow Court. You cannot, under any circumstances, Miss, go over to that house.
Yes, sir.
Concern for their child or not. You'll be subject to residential confinement. Fitted before release. Shall not possess firearms or weapons. Must reside at 2209 Kitski Lane, Unit C, and be subject to pretrial supervision. All right, you're able to post bail in the amount of $200. You'll be subject to those conditions. All right.
Thank you, Your Honor.
Your Honor, just one point of clarification. I would ask that the no contact order also include or Miss Manuela's husband, Todd Pardula.
I did.
Thank you.
Yeah, I did both them as well as the address on Oxbow. All right. Next is Alina Padron.
With Ms. Condrone, we weren't able to speak with her today. We would ask just for a one-day continuance.
No objection.
All right. All right, so we had two cases for her. So be brought back tomorrow. All right, next individual is Willie Eccles.
We spoke with Mr. Eccles today. We would ask to waive his appearance and proceed with the bail hearing.
All right. All right, is the state ready to proceed with Mr. Eccles?
Yes, Your Honor. Your Honor, in this case, we're not going to object to his release. We would ask that he be supervised by pretrial supervision and tested for drugs and alcohol. He does have, score that 11 on the risk assessment. He does have some recent concerning history with failure to appears. He had 2 failure to appear arrests in 2024, as well as a contempt arrest. However, his only recent conviction is a misdemeanor drug paraphernalia from 2023. It looks like he had some drug arrests between 2002 and 2020 with no disposition. Prior to that, though, it does look like he had a habitual criminal conviction for aiding and abetting a robbery in 2006 and criminal history going back to 1972. However, given the lack of recent criminal history and the facts of this case, we do believe there are least restrictive means.
And you think he'll show up based on his FDA score?
Tough to say, Your Honor. His most recent failure to appears were 2 years ago. So I think given the facts of this case, this was a camping near the Truckee River and a jar in plain view. So I think one chance would be appropriate.
All right, fair enough. All right, so he's going to be released, subject to testing, pretrial supervision. All right. Next is John Jackson, followed by Carrie Lapinier. All right, stay ready to proceed with Mr. Jackson's.
Yes, Your Honor. I would just note that in the probable cause sheet, it did not list the victim or the protected party of the protection order. It does look like that is Kelly Gower, Kelly, last of Gower. We were able to contact her last night. She is supportive of a no contact order. Reports that she believes Mr. Jackson suffers from both drug and alcohol abuse. So, Your Honor, in this case, the state is going to seek bail in the amount of $25,000 bondable, pretrial supervision with testing for drugs and alcohol, no firearms or weapons, and absolutely no contact with Ms. Gower. Mr. Jackson scores a 9 on the risk assessment, noting pending cases in the Reno Municipal Court. Already this year, he was arrested on a violation of a domestic violence TPO that was dismissed out of the Reno Municipal Court. Last year, he had a trespassing conviction out of Reno Muni and a failure to pay, failure to comply arrest. He had a DUI conviction in 2023 out of this court and another DUI conviction in 2011 out of this court. So given that and the history, Your Honor, as well as the victim's wishes, we do believe that bail is appropriate in this case. I would just also note that law enforcement noted he was 10 feet from the residence when they contacted him.
Right. Yeah, and I had her in the you said you were not able to find her in the PC sheet?
Contact information wise, Your Honor.
All right. All right. All right, do we have a response, Mr. Merritt?
Yes, at this time, we're seeking a more modest amount in bail to the effect of $3,000 bondable with a 10% cash option. While Mr. Jackson scored a 9 in the MPRA, there are no points for prior felonies, prior violence, prior failures to appear, and no points for prior multiple substance use arrests. I think that mitigates much of the risk he poses to the community at large, along with his status as having a flight risk. In addition to that, he is currently looking for work, so he is expecting to get employed very soon. In addition to that, if afforded an opportunity at pretrial release, he would be able to find local housing. He does have sufficient funds on his debit card to sustain something to that effect, and he is cordial with any pretrial release conditions the court believes is appropriate. I think it's just important to keep in mind that in this case, it just amounted to inappropriate contact. There was no physical violence. There was no theft. That should be figured into the amount of bail considered at this time.
And Your Honor, I apologize, but I did have one other note from my investigator regarding the victim's wishes this morning. She did indicate that she wished that the judge advise Mr. Jackson that the TPO is not fake and that he cannot be near her given the TPO.
Well, I'm just trying to be a father. I was just trying to get my.
Mr. Jackson, you don't want to make statements.
So let the process run its course, Mr. Jackson. All right. The EPO says 100 yards. Under no circumstances can you be within 100 yards of that residence or Ms. Gower. All right. So your bail is going to be set at $10,000. Given the facts of this case, you'll have to stay away from 1665 Wedekind, Unit F. That includes Ms. Kelly Gower. You'll be subject to testing, shall not possess firearms or weapons, and you'll have pretrial supervision.
You're able to go back.
This way, sir.
Morning.
All right. Is the state ready to proceed?
Yes, Your Honor. In this
Ms.
case,
Lapp-
yes, Your Honor. In Ms. Laffiner's case, we are seeking bail in the amount of $15,000 bondable, pretrial supervision with testing for drugs and alcohol. Ms. Laffner does score 7 on the risk assessment. Her criminal history includes a misdemeanor tampering with a motor vehicle out of the Sparks Justice Court from last year, as well as a drug paraphernalia conviction out of Reno Muni last year. She had a petty larceny misdemeanor in 2017 and a misdemeanor possession of marijuana in 2008. Your Honor, the basis for the bail request is the likelihood of conviction in this case. She did provide the name and date of birth for Brittany Laffner, which did return to a true person given local criminal history. So we do believe that bail is appropriate in this case.
All right, do we have a response?
Yes, at this time, we're seeking an OR release for Ms. Laffner, along with pretrial release conditions. I think given the factual allegations, random drug testing would be appropriate, along with check-ins with pretrial services. Her MPRA score is a 7, no prior felonies, no prior violence, no failures to appear, and no multiple substance use arrests. I think when you look at her criminal history, much of it, in my eyes, pertains to drug use and drug abuse. It's not really to the effect of victimizing others in the community as much as it is her victimizing herself. The only solution to that is through treatment, is through substance use treatment. It's not going to be fixed by additional incarceral time, nor is it going to be benefited through the continuous disruption of her life. She reported to us that she currently works at a tattoo shop. She does have housing of some kind, and she does have a personal phone. We weren't able to touch base with her reference, but had we were able to, that would have marked her from a 7 to a 3, which would have made her a low risk. I think her criminal history reflects that she is truly a low risk to reoffend, along with a low risk to the community. And that's why I do believe an OR release at this time with drug testing is sufficient means to protect the community and ensure future court attendance.
Well, again, tend to agree with that, but for the fact that she provided the ID of her sister, finally admitted that the ID was incorrect. I am going to set her bail, but it's not going to be at 15,000. It's going to be at 5,000 with a 10% cash option. She'll be subject to testing. Do you still reside at 255 Smithridge Parkway, Miss?
Yes, I do.
Is there a unit number associated with that?
No, that's the house number.
All right, so you're gonna have to reside at that address. All right, pretrial services supervision. In the event that you're able to post.
And Your Honor,
subject to the conditions.
given the facts of this case and the limited criminal history, if Ms. Laffner is interested, I would also have no objection to an OR release to inpatient treatment.
I will do that.
So either or, correct?
Correct, Your Honor. The bail or release to inpatient.
And that would be direct transport, correct?
Correct, Your Honor.
All right, so I'll add that to my JRO.
Thank you.
Okay, next individual is Mr. James Seeger or Setter.
Good morning, Your Honor. That's Seeger.
Seeger, all right, thank you for that correction. Okay, is the state ready to proceed?
Your Honor, I would just note that we were able to get a hold of the victim. She did indicate she wished to be present this morning, and she was provided the Zoom link. I would just inquire of the clerk if we do have her.
We do not.
In that case, Your Honor, I am prepared to move forward. The victim, well, the mother of the victim in this case is supportive of a no contact order. Given the facts in this case, I do believe it is absolutely appropriate.
Right.
I am going to request bail in the amount of $25,000 bondable. pretrial supervision with testing for drugs and alcohol, the no contact order. I would ask that that be both pursuant to order and pursuant to statute in this case. No firearms or weapons. And house arrest with GPS monitoring. Mr. Seeger scores a 6 on the risk assessment. That assessment also noted his BAC at intake to be a 0.136. His only criminal history is an arrest for a domestic battery first offense in 2013 with no disposition. However, Your Honor, given the facts of this case, extremely concerning given the vulnerability of the victim in this case, SS, extremely concerning facts. So we do believe that bail is appropriate in this case. I would just note that it's my understanding the mother of the victim, Miss Louisa Paget, was arrested on domestic battery charges as well. I'm not sure if that was in regards to this case or not. She was slightly incoherent with our investigator this morning, but that may be the reason for her non-attendance.
All right, do we have a response?
Yes, at this time, we're seeking an OR release for Mr. Seeger with appropriate release conditions. I believe the no contact order is appropriate given the facts and circumstances, along with random alcohol and drug testing. Given Mr. Seeger's lack of criminal history, he is more than appropriate for an OR release, even given the factual allegations of this case. It's involving an intrapersonal family dynamic issue, something that is, I mean, the harm within can be completely mitigated with the suggested random drug and alcohol testing and the no contact order. I don't believe house arrest with GPS monitoring is appropriate, just given the lack of criminal history and given the absence of persistent violence in the home from Mr. Seeger. His score on the MPRA was a 6. Indicating no prior misdemeanors, no prior felonies, no prior violence. He's not a risk to the community. He's not a risk to reoffend, truly. I think that's reflected again, right? His criminal history only has 1 prior arrest from over a decade ago with no disposition as well. In addition to that, he has no prior failures to appear, no multiple substance use arrests. We were able to verify his employment, his ability to retain housing separate from the victim in this case. And along with that, he does have a personal phone, right? That would mark his MPRA score on the modest end down to a 4. So still a low risk. But if he is able to sustain housing hereafter away from the alleged victim, that would potentially mark his score down to a 2. Again, the factual allegations of this case don't amount to something warranting nor necessitating monetary bail in itself, certainly not $25,000 bondable. I do believe Mr. Seeger, if afforded that opportunity at pretrial release, he would be successful because there is no indication that he wouldn't be.
All right. Mr. Heydrich, this felony, what category is this felony?
Child abuse is a category B felony, Your Honor.
As in boy, correct?
I'm sorry, what was
D.
that? B as in
Category
boy.
Okay. Well, again, the facts of this case are also concerning. He was drinking and he punched and threw his daughter to the ground, and she's only 15 years old. The other concerning fact of this case is, no, it's still only an allegation at this point, but he told his daughter that she would get cut open and raped at this place. So I am going to set his bail at $15,000, no 10% cash option, no contact with 701 East 7th Street, Unit 229. The named minor in the probable cause sheet as well as Louisa Paget is going to be subject to residential confinement. He's going to be subject to testing, shall not possess firearms or weapons. He's going to have to find someplace else to live He cannot go back to that residence, and he'll be subject to pretrial supervision.
All right, sir, get it back.
All right. Next is Sean Walton, followed by Hector Jimenez. All right, is the state ready to proceed?
Yes, Your Honor, we're going to request bail in the amount of $2,500 bondable pretrial supervision with testing. Mr. Walton scores a 12 on the risk assessment, noting the point for prior failure to appear and 2 points for prior substance abuse. He had a battery conviction out of this court from last year. He also had a drug paraphernalia conviction out of this court from 2022. He had failure to appear arrests, multiple in 2021, 2019, and 2017. He had a felony conviction for attempted intent to utter a fictitious note in 2021. Excuse me, he also had another, so 3 separate failure to appear in 2021. He then had a felony conviction for selling a controlled substance in 2016 and a misdemeanor possession of a controlled substance in 2016 out of California. So given that he was wanted on a warrant when he was picked up on this case, given the amount of narcotics on his person, we do believe bail is appropriate in this case, especially noting the failure to appear history.
All right, do we have a response?
Yes. So at this time, we're seeking an OR release for Mr. Walton with appropriate release conditions. I think just given the facts and circumstances of this case, random drug testing is probably the only reasonable release condition. While Mr. Walton scored initially a 12 on the MPRA, he does have a verified phone. He did report to us that he does have an address he could return to if afforded that opportunity. We just weren't able to get into contact with his reference. After all, it was early in the day today to be calling someone from a random number. But in speaking with Mr. Walton, I think he recognizes that he does have a substance use issue and he would appreciate an opportunity at random drug testing. I'm not sure he's been afforded that opportunity in prior cases. I know with his last battery case, I feel like Mr. Walton likely remained in custody during that time because I was present at his bail hearing for that. Again, this case doesn't involve violence, theft, selling drugs, anything like that. It is simple personal use, and it was fairly inoffensive up until the mobile engagement team decided to talk to Mr. Walton about outstanding warrants. Otherwise, Mr. Walton was seemingly a lawful individual, just minding his own business. Again, any danger to the community or himself or any risk of flight can be mitigated with random contact in terms of random testing with pretrial services. And so we will submit with our OR request.
And Your Honor, my apologies. This is another case where I would not object to a release to inpatient via IAP if the court does impose bail.
Yeah, I was just wondering why this wouldn't be the same situation. All right, so I have his bail set at a lesser amount. It's going to be 2,000 or 10% cash, subject to testing. I know it looked like they were able to verify through his reference pretty much everything except his address. Do you still reside at 1066 Lodi Street, Unit B?
Yes, sir, I do.
All right, and that's in South Lake Tahoe?
Yes, sir, it is.
All right, so you're gonna have to reside at that address. You'll be subject to pretrial supervision. Then I'm also gonna put a provision in there that it says if you're able to find a bed in an inpatient facility, you'll be directly transported to that facility for substance abuse treatment. All right,
I'm not understanding.
So talk about it over here.
Okay.
well, your lawyer will explain it to you.
Thank you, sir.
You're able to talk to him? Yeah. All right. Where's his message?
All right,
Morning, Your Honor.
morning.
Hey.
All right, are we able to, is the state ready to proceed with Mr. Jimenez?
Your Honor, on this case, I will be requesting a 24-hour continuance for Marcy's Law contact. We attempted to contact the victim this morning and have not received any callbacks. The arrest was yesterday.
Right. All right, well, this situation is different than the other one. So, I'll carry this over for one additional day. Next is Richard Reynosa.
That's correct. We spoke with Mr. Reynoso. We would ask to waive his appearance and proceed with the bail hearing.
All right. State ready to proceed?
Yes, Your Honor. Mr. Reynoso was seen, I believe, yesterday or the day before and was held on bail of $150,000. Given these new facts of the eluding and possession of a stolen motor vehicle, Your Honor, we'd ask that an additional $50,000 be included in that. Given the timing of the case, this may be merged with that, but I cannot say for sure yet. Mr. Reynoso scores an 11 on the risk assessment, and I believe you were the judge who I listed his criminal history to yesterday, but I'm happy to go over that again with you if you would like.
No, I actually went through the PC sheet. It's pretty extensive. So the other cases at 150 are asking for on this ad book case for 50,000.
An additional 50, yeah.
All right. We have a response?
Yes. At this time, we're seeking a lesser amount in bail. Given the facts and allegations of the case, along with an eye towards Mr. Reynoso's criminal history, I do believe 20,000 bondable with no 10% cash option is more appropriate. His criminal history and the factual allegations in this case are concerning. That in itself necessitates monetary bail. I think the matter is just the amount in which it's appropriate. He's currently sitting on $150,000 bondable bail out of his other case. He has no means to post any amount of monetary bail. So I don't believe 50,000 is necessary. I do believe you can achieve the same with 20,000 bondable. Having spoke with him previously, he did indicate that he was employed. He would be staying locally, likely at the CARES campus, and he would be contactable for the sake of pretrial supervision if afforded that opportunity. But again, he has no means to post any amount of bail. I do believe 20,000 bondable is more appropriate.
And Mr. Heydrich, I had a difficult time in going through the PC sheet, identifying. It looks because I have a no contact order. I have Thomas Nolan.
Yes, Your Honor. I know they listed the name of the victim at the very end of the probable cause when they attempted to use the key to restart the vehicle. Actually, I don't
Looks
think.
like he responded to 540
Cranley Drive.
Right, he'd meet with the victim.
Yeah, I don't know if they actually listed the victim's name, Your Honor.
And then early on in the, let's see if I can identify him. He contacted the registered owner as Thomas Nolan.
Yes, I believe that would be the case, Your Honor.
All right, so I have both those in my no contact. And they also found, well, long story short, I mean, given his extensive criminal history, 50,000 is appropriate in this case. Shall not possess firearms or weapons, pretrial supervision. He led these officers on a high-speed chase, ran 2 red lights. So those are facts that are extremely concerning. All right, so that's what my JRO is going to say based on the conditions.
Thank you, Your Honor.
All right, and I'm showing that Richard's the last individual. Is that accurate?
You have a Richards?
Reynoso.
Richard
Yes.
Reynosa? I called him by his first name.
Okay.
Is
Yes,
Rich-
that was the
Rich
last one.
Okay. All right. Sorry about calling you Mr. Barnes, Mr. Merrick.
I appreciate it. Thank you, Judge. Have a good one, Judge.
All right.